Be ready. 5 seconds. Start. Aggrieved by the judgment and order passed by the sessions judge, the appellant's preferred criminal appeal number 509 of 2001 before the High Court, which has been partly allowed by the High Court by the judgment and order impugned in this appeal. Stop. The High Court, upon a fresh appraisal of the evidence adduced by the prosecution and the defense, came to the conclusion that the former had failed to establish the charge under Section 302 read with Section 149 of the IPC framed against the respondents. Stop. The High Court observed in the instant case from the deposition of Dr. Mathur, it is more than clear that all the injuries found on the persons of the deceased were simple in nature. Stop. 3 injuries were found by pointed object and other were abrasions. Stop. It is not in dispute that the 3 injuries found on the person were all simple in nature and by blunt object. Stop. The injured Shambhu Lal received 2 grievous injuries. Para. The High Court has on the above basis acquitted the respondents of the charge of murder but upheld their conviction for the remaining offences. Stop. On the question of sentence, the High Court found that the respondents have been in custody with effect from 24th January 2000 and accordingly sentenced them to the period already undergone. Stop. The High Court observed, consequently, the appeal is allowed in part. Stop. The appellants are acquitted of the charge punishable under Section 302/149 of the IPC. Stop. Regarding other offences, the findings of guilt arrived at by the learned trial court is maintained. Stop. So far as the question of sentence is concerned, the appellants are in custody with effect from 24 January 2000. Stop. In the totality of circumstances, we are of the view that in the circumstances of the case, a sentence of imprisonment already undergone would meet the ends of justice. Stop. Consequently, the sentence awarded to the appellants is modified to the extent that they are awarded the sentence already undergone by them. Stop. The judgment of the learned court shall stand modified accordingly. Stop. The appeal is disposed of in the manner indicated above. Stop. The appellants shall be released forthwith if not needed in connection with any other case. Para. We have heard learned counsel for the parties at some length and perused the record. Stop. The High Court was, in our opinion, justified in holding that the prosecution had not been able to establish the charge of murder beyond a reasonable doubt. Stop.